Vsoft Holdings.
May it please your lordships, I'm Selim Moulan. I appear for the appellant in the main appeal, Vsoft, together with my learned friends Peter Webster and Murari Gajadar. My learned friends Iqbal Rajabali and Mushtaq Namdarkan appear for the respondents in the main appeal, Peepul and Millennium, whom we have referred to as the funders in our written cases. And my lords, I will keep using that terminology to avoid any ambiguity about appellants and respondents. So we'll refer to the other side as the funders and to my clients as Vsoft. My lords, my submissions today will be directed at the main appeal, that is Vsoft's appeal against the Mauritian Supreme Court's decision to refuse the setting aside of an award rendered by sole arbitrator André Domingue, senior counsel, on the 8th of January 2015 under Section 39 of the International Arbitration Act of Mauritius, which I will refer to as the IAA. It is common ground between the parties that the freezing injunction obtained by the funders against Vsoft stands or falls with that Section 39 application. My lords, I will say a very few words at the very end of my submissions today about our injunction, but not very much at all, because we will have traversed the evidence that goes to that as we go through the main appeal. My lords, the present appeal is, to our knowledge, the first case which has reached the board under the IAA. The IAA is a modern arbitration statute based on the model law on international commercial arbitration of the United Nations Commission on International Trade Law, or UNCITRAL. It adopts the stance, the pro-arbitration stance of the model law and of most modern arbitration laws. But, my lords, importantly, that pro-arbitration stance is subject to limitations, which are set out in particular in Section 39, and which are designed to protect parties where the arbitral proceedings go seriously wrong, as we respectfully submit has happened in the present case. In interpreting the IAA, case law from other model law jurisdictions such as Hong Kong, Canada, New Zealand, or Singapore is of particular persuasive relevance. My lords, as you will have seen from our written case, and that's in the record, pages 1768 to 1821, it is our position, it is Vsoft's position, that this case turns essentially on a question of fact, namely, whether the arbitrator failed to decide issues which he ought to have decided because he labored under a misapprehension that the said issues had been conceded when they had not. Alternatively, we say, if those issues were conceded, Vsoft submits that that concession was made because of a breach of due process by the arbitrator in the form...
That may be what you have to focus on, because Mr. Chetty said in terms that our position is as follows, and has always been as follows, that the respondent does not dispute the claim of the claimants.
But these words need to be understood in the context of the submissions that were being made before, and also if you look at the totality of what Mr. Chetty is saying at page 828, my lord, he says the claim is not in dispute. I would also pages 828, I think where my lord Reid was looking at, is page 828 of volume 2 of the record. So you have the long intervention by the arbitrator.
Yes.
And then you have what Mr. Chetty responds. And my first submission is that we will have to go through that with some care, my lord, to understand what the submission was before that response. But just looking at that response, my lord, what he says is as follows and has always been as follows. Well, that's not, first of all, that's not consistent with the concession. But then he goes on to say the claim is not in dispute. I would also like to dispel the impression that I was not putting the case of the claimants, inasmuch as we're not disputing the claims of the claimants. My instructions have always been that we're not disputing the claim of the claimants, but the difficulty of the respondent is at this particular stage where we are in the implementation process. And to that extent, the respondent has no objection that you, Mr. Arbitrator, determines where we are within the process and determines the amount payable according to that particular process. Now, my lord, that has to be understood in the context of the submissions that he was making, that there was a tension between the way in which the parties had behaved and the regime under clauses 3 and 5 of the agreement. And I will show you, my lords, on the pleadings, that the point was live and clearly taken that because the process under clause 5, the implementation steps had not been followed, the obligation to pay under clause 3 did not arise.
And if you go on to his next intervention on page 829, as I say, the claim is not in dispute, but it is the determination of the quantification of that claim. And we would like to seek your assistance in the present matter. This is our position.
Well, which is, we respectfully submit to be read, one, by reference to what he has just said about the implementation process, because you will remember the submission that was being made, my lord, is that because there is, the way Mr. Chetty was putting it, because there's a legal imbroglio as to the position under the implementation process under the shareholders agreement, one had to look at this accrued rights provision of the investment agreement. And of course, that would then make a huge difference, because you would either calculate $8 million plus interest from December 2006, or you would calculate 15% ex-IRR on $17 million from the date of the shareholders agreement. So that's the submission that was being made. And if you look at what the witness was also saying, is I'm prepared to pay under the investment agreement. If you look at the letter that comes after that submission, my lord, from Vsoft, it is quantifying on the basis of $8 million plus interest from December 2006. And if I may, my lord, if you just turn back to page 822, so this is before the arbitrator's intervention. 822. So the closing submissions.
Yep.
Well, I was hoping I could do this in a more orderly way, my lord, but I think you had better look at this now. If you look at what Mr. Chetty is saying about halfway down the line, the longer intervention, the stand of the respondent is that it is not contesting, I think this should read, the wish of the claimants to exit. Neither is it contesting that there are two letters. And he's referring to the letter from Mr. Murthy himself and the letter from Mr. Ravi Prasad. The respondent is not subtracting itself, stands by those letters, annexures 4 and 5, pages 32 and 33. But because of the legal imbroglio that we have found ourselves in, there is a claim, we're not disputing that, but how do we quantify that claim in the present state? This is the question. This, my lord...
I may have picked up a wrong page. Are you still on 822?
I am on 822, my lord. You've got a long intervention by Mr. Chetty, or the longer one.
Yeah.
Then arbitrator says the respondent.
Yeah.
And if you read on.
Yes, I've got it, yes.
And the point I'm making, my lord, is that he is referring to that exact issue, and of course that has to be seen in the context of everything he's saying before, the question of the interaction between clauses 3 and 5 of the shareholders agreement as one which goes to quantification. And you will see that the witness, Mr. Viraganta for Vsoft, is also saying, well, I'm prepared to pay under the investment agreement. Now, my lords, that may have been right or wrong, but the arbitrator had to decide it. He had to decide.
I'm not keeping up with this. Where is the formulation of the question which you say the arbitrator had to decide? I mean, he's saying it's all a problem and there's an imbroglio and all that.
Yes.
Where does he clearly state what is the point he's trying to... has not been conceded?
My lord, if going back then to the beginning of Mr. Chetty's closing submissions, which is at page 816. He makes a first submission towards the end of page 816, and you see about, it's 5 lines up from the bottom. My first submission is that the investment agreement cannot be taken to be abstracted completely from the present matter because of the accrued rights provision. Then, if you look at the top of page 818, and he starts, on page 817, he describes clause 3 of the shareholders agreement, then he goes to clause 5 at the top of 818, first line of 818. In my submission, clause 5 is more important in the reading of the document, the shareholders agreement. Clause 5 is the clause setting out mechanism which bring clause 3, which bring into play clause 3. And that mechanism is absolutely important. The parties shall do all acts necessary, investors exit. These are matters which have to be attended to before clause 3. And then the arbiter intervenes, and if you look at what he then says, probably it is the appropriate stage to refer to that letter of the 8th of October 2012. And he says it's then that the claimants, on the 8th of October 2012, surrender their share certificates. And he says there's a direct nexus between clause 5 and that letter. the arbitrator agrees and says, in fact, the letter does refer to Article 5. And Mr. Chetty says, and rightly so, because this is the mechanism for the exit. These are the steps that have to be taken for the exits. That date is important. And this is my second submission, that prior to the 8th of October 2012, nothing could be done. This is my second submission, that prior to that date, 8th of October 12, nothing could be done because the exit steps had not been fulfilled yet. And then again, lower down, the last intervention on the page, third line, there must be a surrendering first and the further steps to follow. And this is what leads him to the submission of a legal imbroglio, my lord, which you find at page 821. Starting from the top of page 821, the 8th of October 2012 gives the first date to set it into action, because it is only then that the surrender can take place. After surrender, the document contemplates cancellation. The shareholders' agreement contemplates demand promissory note. So a claim cannot be made any earlier than the 8th of October 2012. And may I add that until that date, the share transfer forms have not yet been signed. That's reference to a share transfer form which comes later in time in August 2013. When we go back to the statutory demand, which was a demand on the promissory note, being the extrajudicial act leading to the winding petition, leading to the present arbitration, it appears to the respondent that an event of default occurs on the part of the respondent, and that event of default is crystallized at latest 31st of August 12, because this is the first paragraph of the statutory demand, and again our submission is that this sits uncomfortably with the mechanism prescribed in the shareholders' agreement, in that the material date can only be October 2012. It is a further submission that, this being the case, we are in a situation of a legal imbroglio where somehow the prescribed steps are not being followed. So that the claims of the claimants as put forward by them, it is important to situate that claim in accordance with which legal document and, more importantly, with which legal regime. And this then, my lord, you get to the passage which I was just taking you to, where he's referring to that question as a question of quantification. Because he's saying, which legal regime? Which legal regime has two questions within it. One, are you under the investment agreement? Or are you under the shareholders agreement? Two, if you are within the shareholders agreement, what is the interrelationship between clauses 3 and 5? And he's saying very clearly, if you're under the investment agreement, it's $8 million. That was the pleaded position. And he's saying, if you're under the shareholders agreement, then something has gone wrong. The obligation to pay hasn't arisen. And he refers to this, my lords, as a question of quantification. And
Sorry,
when he
if you're under the investment agreement, it's $8 million.
Indeed.
If it's under the shareholder agreement?
17 million.
17 million.
And the interest rate under the shareholders agreement is 15% ex-IRR, which is an Excel formula. My lord, there's an easy way also to look at this.
Yes, I mean, that point you just expressed very clearly. It doesn't spring out from the page, does it?
On the investment agreement?
Well, no, on this page 821, you just said there's a very straightforward issue as whether it's under the investment agreement, 8 million, under the shareholder agreement,
my lord,
17 million plus 15% interest.
If I can make that
That
good,
is not expressed anywhere I can see here.
Well, because, my lord, what I was intending to do with you today, but I appreciate why we need to do this, and I need to satisfy your lordships that there is some substance for you to look at. But we would submit the proper way to do this is to look at the pleadings, where you will see the issue pleaded, to look at the evidence, where you see what is being said.
At the moment, we're just trying to understand the legal imbroglio, and you've explained to us what you think it is anyway.
Well, the legal imbroglio, my lord, is the clause 3, clause 5 point.
Yeah.
The investment agreement point you find in the pleadings, and you find in the arbitration agreement itself, where perhaps I'm going to show you...
So just completing this process, you're showing us the sort of run-up to the so-called concession. Is there anything else we need to look up?
Yes, my lord, if I may, which is something which comes after the purported concession, which are these letters which the parties exchanged on quantum.
But I mean, clearly, standing back, the impression given by Mr. Chetty was that he was conceding the claims, and clearly that's what the other side understood, because they say, well, then we don't need to say much about that. And well, the hearing completes itself on that basis. Now, you say there's some letters which clarify the position.
My lord, we respectfully submit that the fair way to look at this transcript is that here is counsel trying to explain a point, meeting very, very, very strong resistance from the arbitrator and politely saying, well, it's always what I've said, which is not consistent with I'm conceding my case. And he's saying, I accept payment, yes. And you will see the witness had also said, I accept payment. And when asked, oh, you accept payment, he said, yes, under the investment agreement. So that had been the position. But if there were any ambiguity, my lord, if we could look briefly at the correspondence which is exchanged after this, and which
if you read on, say, 824, the arbitrator in the middle of the page asks Mr. Chetty, what are you saying? And there's an interjection from Sir Hamid, investment agreement or shareholders agreement. Mr. Chetty, the present claim is under the shareholders agreement. If you follow that route, you must also follow the procedures that are inbuilt in a particular document. As per the statutory demand, the claim is being made under the shareholders agreement. Now, and he goes on, this is why I said the legal regime should be clearly followed, because each legal regime set in motion its own characteristics. Now, all this seems to be suggesting, well, it's absolutely clear that the claim has been made under the shareholders agreement. He seems at this point to be saying, but there is no liability because the procedures laid down have not been followed. But as we saw earlier, he then goes on to concede that liability is not in dispute.
My lord, first on the investment agreement, when you say the claim is under the shareholders agreement, you will remember that the arbitration agreement, and we can look at that if you wish.
Well, are you not, before we go any further, are you disputing that, according to Mr. Chetty, the claim is under the shareholders agreement?
The claim, at the time we get to the closing submissions of the claimant, is under the shareholders agreement. That's the only point he's making. If you look at the previous page, my lord, where he was talking about legal imbroglio, and you look at that submission again, it concludes with this. So he explains there is a legal imbroglio, and to that extent, I have tried to find an answer. I have tried to see whether the investment agreement, because of the survival of the accruing rights, can help. This is where he's reached in his submissions. And then, with all due respect, he faces a barrage of questions from the arbitrator, then a long intervention, and then he comes back and says politely, well, I maintain my claim. This is what I've always said. We accept that we need to pay something. We need you to determine where we are in the implementation process. Now, with respect, my lord...
That's not what he says. You're doing a very good job. But on page 829, he says, as I say, the claim is not in dispute. And the claim, as you just said, is a claim under the shareholders' agreement. So... to an ordinary person, I come to this fresh. It seems to be plain as a pikestaff.
Save, my lord, with respect, does one read that sentence disconnected from what he has just said, which is that one needs to determine where we are in the implementation process, where he has just made the submission prior to the intervention, that where we are in the implementation process may lead to a situation where one has to fall back on the investment agreement.
Well, I mean, what he said after the arbitrator's intervention may not be in every respect consistent with what he was saying beforehand, but it seems to me at the moment to be unambiguous. That the respondents are not disputing liability under the shareholders' agreement, but they want the arbitrator to determine the quantification of the amount due.
Well, we would respectfully submit, if one is to read a concession into that, then there needs to clearly be a concession. And you fairly said, my Lord Conworth, that maybe I was paraphrasing what Mr. Chetty said, but with respect, I think now my Lord Reid is also paraphrasing what Mr. Chetty said, because he doesn't say under the shareholders' agreement. He doesn't. He says, I'm not disputing that something needs to be paid. He's saying, but where are we in the implementation process? But my lord, why would that matter if all you need to do is enter $17 million in an Excel spreadsheet, press enter, 15% XIRR, and you've got an answer?
He doesn't mention the investors' agreement in the critical passage we're looking at. 828 when the hearing resumes, I was submitting, as regards the shareholders' agreement, our position as regards the two documents and the shareholders' agreement is as follows. So it's a shareholders' agreement that he's talking about, and liability under that agreement.
My Lord, again, you have my submission. We see this cannot be read disconnected from what he was just being said, particularly when he says, has always been as follows. Again, if one is to find a concession from counsel, I think it has to be clearer than that. And perhaps now, if I may take you to the correspondence.
Just before we look at the subsequent correspondence, don't we have to look at this in the context of the events which had led to the dispute? There had been an investment agreement, there was a termination agreement that put an end to the investment agreement, and then there was a shareholders' agreement. And on one view of Clause 5, there was a late compliance with the obligation by people to surrender the shares. They were then surrendered, and that led to a letter from Vsoft saying, thank you for the surrender, we accept we're still liable to you under the shareholders' agreement. I'm paraphrasing it a little, but there was a clear acknowledgement that the shareholders' agreement was still in force and continued to govern the parties' liabilities. Now, that's the immediate factual context of all this discussion. I'm trying to discover from the passages in Mr. Chetty's submissions what sort of case was being or could have been advanced that the investment agreement was still on foot. And all I found is a reference to a legal imbroglio.
My Lord, two answers, if I may, to that. First, I think what you're saying is that it's difficult to see what the case would have been under the investment agreement. Yes. But you will remember that the claimants themselves in the arbitration agreement also put the issues that were referred to the arbitrator included. Yes. Whether the rights had
I understand that was, as it were, raised as a... But I can't see anything in the papers that constitutes a properly formulated case that the investment agreement was still in force.
And that, my Lord, would be my second answer, which is that when Mr. Chetty gets to the submission which I was showing to you a moment earlier, that he has tried to see how the investment agreement can help, he stopped. He stopped and stopped and stopped until we have the long intervention. And the witness for Vsoft, Mr. Viraganta, had said time and again in his oral evidence that he was prepared to pay under the investment agreement and not under the shareholders' agreement.
I can quite understand that a witness might say that.
Yeah.
The question is, what legal basis was being put in front of the arbitrator by this late stage to clothe what the witness commercially would like to have done with any legal reality?
My Lord, the submission, again, I think, was simply on the basis of the fact that there was an impasse under the shareholders' agreement, and therefore that he was trying to see how the investment agreement could help. But that's one aspect, my Lord. Even if you're not with me on that, there remained the question, which was still put to the arbitrator, as to the interrelationship between clauses 3 and 5, which is where are we in the implementation process. And my Lord, that's, if I may now bring in something else, that is not innocuous, because if the arbitrator had actually applied his mind to that question, which we submit was on any view before him, even if we are under the shareholders' agreement, he's still saying in that reply, we need to know where we're in the implementation process. The arbitrator would have had to apply his mind to the question of the shares, of the steps under clause 5. We would have a properly reasoned award that would have followed the steps, would have analyzed how clauses 3 and 5 interrelate, and there would be a finding somewhere in this award as to what happened to the shares. And you have our point that we say we have suffered serious prejudice from the fact that this award doesn't do that. And that question was put to him. My Lord, may I now go to the correspondence, because we do say...
Before we leave the transcript, you'll see that after Mr. Chetty said what he said, Sir Hamid then responded. And you see he begins by saying, my learned friend is leaving the issue of quantum to the arbitrator. Then he goes on 8:30, towards the end of the first paragraph. I will humbly submit what is left for the arbitrator. The quantum is clear. There's no ambiguity on quantum. You're asking, it's the sum due. There's only one issue, which is, alas, the cost. Then there's a short exchange with the arbitrator, and he goes on, therefore the only calculation which is left to the arbitration is to do for the only calculation which should be left to the arbitration is the interest to be computed at 15%, XYRR. Don't ask me to do it, but Mr. Arbitrator, there should be a judgment in favour of the claimants. So he's obviously addressing the arbitrator on the footing that the implication of what Mr. Chetty has said is that there's only a question of quantification, and in reality, the only issue of quantification that remains to be done is the interest calculation, because the capital sum due under the shareholder agreement is plain. And that's the basis on which Sir Hamid concludes, and Mr. Chetty doesn't say a word. I mean, if this was wrong, if the arbitrator, because the arbitrator just responds by saying, I'll therefore take time to consider, and Mr. Chetty, the only thing he does is to thank the arbitrator for his patience and understanding.
But my lord, on this, first of all, the position of Sir Hamid throughout the proceedings, and if we go to the cross-examination of the witness, is that there was nothing to say. It was just shareholders' agreement, shareholders' agreement, shareholders' agreement, and those two letters. That's all. There was never anything else. There was no engagement at all from the other side as to the interaction between clauses 3 and 5. So with respect, I wouldn't read too much into that. Secondly, what the arbitrator is inviting at page 829, so the first intervention from the arbitrator on page 829 is we have to hear the reply of Sir Hamid. So basically, we've had closing submissions from Sir Hamid, very short. We've had closing submissions by Mr. Chetty, cut short. And now he's inviting a reply from Sir Hamid. My lords, it's not litigation that one is under a duty to reply to a reply. Again, my lord, we are talking about a concession, an abandonment of a case.
If counsel, if it was clear that Sir Hamid had completely misunderstood what Mr. Chetty was meaning, and in asking the arbitrator, in telling the arbitrator all he had to do was work out the interest calculation, this was a complete misunderstanding, and the arbitrator, if he went off on that basis, would be doing entirely the wrong thing. It would be the most natural thing in the world for Mr. Chetty to stand up and say, hold on, wait a moment, that's not what I meant at all.
Save, my lord, that he has just been made subject to the most extraordinary intervention. And what I suggest to your lordships is that you have to read this in the context of that room in Mauritius.
I mean, do we? Good, Mr. Chetty, well, I mean, I don't know Mr. Chetty, but I assume he's a competent counsel, and if he felt he had been browbeaten in some sort of way, which certainly doesn't come across in the transcript, we might have some evidence from him to say that. I mean, do we know anything about whether he sort of suddenly felt he couldn't say what he wanted to say?
My lord, one, we submit that he did say what he had to say, which is he said,
well,
maintaining his position.
I'm not disputing the claim, and we see, Sir Hamid actually goes on to say, during the course of heavily contested matters, now my learned friend has dropped all of those matters, and we are left only with something, and so on. So it was clearly that Sir Hamid thought that all sorts of issues which had been in dispute had been dropped.
Well, the
simple issue of quantification.
The counterclaim had just been dropped. That is correct. Yeah. But again, that is the reply from Sir Hamid, my lord. It's not. There's no duty on Mr. Chetty to reply to a reply.
Your submission is that we should somehow infer from this that Mr. Chetty was sort of cowed into silence by an overbearing arbitrator, which of course would be very serious, but
with respect,
there's nothing in the transcript which suggests that at all.
That is not my submission. My submission is that if you are to make a finding that counsel abandoned a case, then there must be clear evidence. There must be clear words from counsel to that effect.
Well,
and at
the
best,
claim is not in dispute. I mean,
well, my lord, again,
can it be clearer than that?
why would one read that disconnected from what he has just said about where we are in the implementation process? With respect, how is it fair to read this without looking at how he has described quantification before? And again, you say being cowed. I say that he is put in a situation where it's clear that the arbitrator will not want to listen much more to what he has to say. He has maintained his position in the nicest and the lowest possible key, and he's moving on. And my lord, you can see that, again, I'm sorry to say, but if one looks at the quantification which comes in from both parties, the arbitrator could not, if he had followed the case, if he knew what the investment agreement entailed and what the shareholders agreement entailed, he could not receive the quantum submission from Vsoft and think that this was an admission of the claim under the shareholders agreement. It's just not consistent. May we look at that?
Yes, where are these letters?
They're just after in the same bundle. So you've got the hearing concluding at 831. Then you've got Peepul sending in its quantification, which is calculated on 15% XIRR, calculated at 12th of October, which is at page 832. And also goes all the way to page 835. You've got the actual calculation in the Excel spreadsheet at 835. And you can see that's a calculation on $17 million, XIRR up to the 12th of October 14. Just an Excel spreadsheet, no implementation process considered there. And if you look at what Vsoft then responds, which is page 836, the respondent has taken cognizance of the communication whilst acknowledging that the applicant is entitled to make a claim, avers that the computation reached by the applicant is wrong, and avers that the following annex table represents the correct computation which the arbitrator should adopt. And if you turn over the page, interest calculations on $8 million, reference rate uses LIBOR plus 2%, and if you look, it's calculated from December 2006. Page 837.
Yeah.
And that is clearly, for you, my lords, who are discovering this case for this appeal, it's obviously a calculation under the investment agreement. How is that consistent with the concession of the point? Now, my lord, he may have said, I disagree. He may have dealt with it in his award. What he could not do is say it has been conceded. And this is where the failure of due process arises. And you have case after case saying you cannot do that. Well, I'll show you cases from other model law jurisdictions saying that is what you cannot do. And I would respectfully submit, my lords, I do understand why your lordships are asking me those questions. But it is for the other side to prove an abandonment of the case. One should not presume something as serious as a complete concession of the whole claim by counsel without the clearest possible evidence. And I say already on the transcript it's not clear, but how can it be reconciled with this letter?
How does it go on? We get the letter the 17th of November from Lager's consult saying that calculations are wrong. Yes?
Yes. And that's it. If the arbitrator felt this is not clear, or how does that mesh with your concession, he ought to have asked for clarification.
That's a rather different argument. When we look at the arbitrator's decision, the award, on page 843, paragraph 11, he's based it, not perhaps unsurprisingly, on what was said at the hearing. He says, at the hearing, Respondent's counsel, after seeking fresh instructions, made it clear, and he quotes the passage that we've been looking at. And so he says, I need not therefore, in the following paragraph, I needn't therefore concern myself any further with the first four issues, the first of which was under which agreement payment was due, as liability has been eventually admitted.
Well, you will note that what he quotes is only the passage which you, my lord, have also been focusing on, which is the one after his intervention.
It's the one that rather leaps off the page at the reader.
Certainly, my lord, it may leap off the page as something which he would like to find. How is it? How does one disconnect that one sentence from his immediate response to the arbitrator, which he has said 30 seconds before? Why is one to be read in isolation from the other? Where has where we are in the implementation process gone? Where has our case has always been as follows gone? Why is it right that the arbitrator can find a concession on the basis of the transcript and the hearing when there have been supervening events which show, we say, that there has been no concession, or at least cast doubt on the issue? How can a party to litigation be held to have given up its entire case on evidence such as this, my lords? That is why we say there is an issue about whether there was in fact a concession. There wasn't. Unless it was absolutely crystal clear, you should not find that there was.
That's the only relevant correspondence, is it?
That is the only correspondence after the hearing. And we say that this letter from Vsoft is clearly a calculation under the investment agreement. If the arbitrator felt, well, what are you saying? Had you not considered the claim, my lord? What does it take to write a letter?
But why can't he just proceed on the basis of what he's been told at the hearing? The whole point about the letter process was that the oral stage of the arbitration had come to an end, and what was being left to the written letters was the quantification of, in relation to what had been determined at the hearing, as left over for debate thereafter.
My lord,
so if the arbitrator was right in his understanding of what Mr. Chetty had said, he didn't have to revisit the matter in the light of the later correspondence, did he?
but the question, my lord, is whether he was right on that. My submission is that in analysing whether there has been a concession, one has to look at, well, I would say one has to look at the submission that is being made before the intervention. Then you have the intervention. Then you have the answer. And the answer refers back to the submissions that were being made before.
I think what I'm putting to you is, isn't it right that one looks to see whether there's a concession or not simply at what was said at the oral hearing and the transcript? If the proper interpretation of that is that the concession had been made, at the moment I'm struggling to see why the later letter changes that position.
My lord, if the concession was absolutely crystal clear on the transcript, perhaps, I think my submission is that, at best, for the reasons I've already given, my lords, what is on the transcript is not clear-cut. And therefore, the letter informs the way in which you look at the transcript. This is a continuum of events. The position of Vsoft is evolving throughout until the award, or rather has to be gleaned from the totality of the documentation until the award. And again, why and how can one read what is, we submit an ambiguous passage the way which it is suggested it should be read, when immediately after it you have correspondence which goes exactly the other way?
Well, we have to bear in mind the role of this court. The arbitrator himself clearly felt that there had been a clear concession made. That's the effect. That's what he's telling us in the award, in the paragraphs we just looked at. The Supreme Court evidently took the same view. On what basis can this court interfere with that?
Well, my lords, first of all, you're not dealing here with an appeal from an exercise of discretion. I'll come back to that in a moment.
No, there's a question of fact was a clear concession made or not?
But, my lord, what you see from the cases, there are two cases in particular which are important. There's one from Hong Kong called A and B, and another one from Singapore called Front Row, which has been followed in a number of decisions.
But they're not dealing with this issue. I mean, they might, for example, help us if the question was, is the award liable to be set aside if the arbitrator failed to deal with an issue that was before him? But we have a logically prior question here. What issues actually were before him at the end of the arbitration hearing?
Well, the reason I respectfully submit those cases will help you is that you see that in those cases, the court is exactly going into that analysis of the arbitral record to see what were the issues that were before the arbitrator, had they been conceded. That was the exact question in Front Row.
Yeah,
and when that goes on...
It obviously depends on the particular facts of the case, whether a reasonable conclusion is that a concession, a point has been conceded or not.
But look, on appeal...
It's not a question governed by authority.
Well, the reason I say the authorities help is that you see that when these cases reach, for instance, the Court of Appeal in Singapore, the Court of Appeal also engages in the exact same analysis of the arbitral record. Why, my lords? Because the question is, has there been a failure of due process? The question is the fact that the arbiter has not determined the live issue going to lead to setting aside of this award? Now, obviously, in order to decide that question, you need to decide whether the issue was live. And in those cases, and this is why this is a case which is a proper one for setting aside, you will have a number of cases where it can be said, well, he may have implicitly decided the issue, etc., etc. And one would normally be lenient with the award, would read the award leniently when that sort of thing happens. But what Front Row shows you, what A and B shows you, what the various cases over the model law jurisdictions show you, is that when you have a situation where an arbitrator says in terms in his award, as this arbiter has said, I do not need to determine that issue because it has been conceded, then the question of fact is one for the reviewing court. And it doesn't stop with the first instance court. Why should it? The Court of Appeal in Singapore also looks at the arbitral record and goes on to determine. Now, Milos, you may not be with me on the facts, and I can see that obviously you've come to this with serious doubts as to how to read that response from Mr. Chetty. I respectfully submit that once you look at the letter and once you look at it in the wider context, you will no longer have those doubts. But what you should have no doubts about is that your task as the ultimate judges mandated under the International Arbitration Act to safeguard parties that are subject to arbitration in Mauritius must conduct the factual inquiry which I've just described and see whether the issues were live or not. Again, you may be against me on that.
Well, you emphasize that this is the first case to come to us under this important arbitration agreement, and so obviously, and we have an award here dating back to early 2015, and here we are 4 years later. Now, I'd have thought that you would accept that we should certainly pay considerable respect to the view taken by the Mauritius court on something like an issue of fact of the review of this transcript.
My lord, with respect, no, because what we are doing is the key issue. It is the key issue in the appeal, which is, was this issue live or not? You've got the arbitral record.
In a sense, we've looked at it and we were trying to see whether there's something seriously wrong with the approach that the Supreme Court took. And as I understand it, all you can really point to is the fact that in the letter, although it wasn't very clearly spelled out, the calculation was based not on the shareholders' agreement, but something else. But
my lord,
that's what it comes to.
But the scheme of the and I'm now looking at the standard of review effectively that you should be applying to the factual question. The scheme of the International Arbitration Act, and if I may say, that's an important selling point that we have put forward to users of international arbitration in Mauritius, is that you are the ultimate court to hear those matters, and that there is an appeal as of right, which is not normally the case in Mauritius, to the board. Now, there's an important distinction, and I want to clear that, if I may, between, on the one hand, deciding whether a ground for setting aside has been made out under Section 39(2), right? That is a question which is entirely reviewable by the court, and this is where we are. There's another question, which is, once a ground for setting aside has been made out, a discretion then arises under the chapeau of Section 39(2) because of the use of the word may. And that's a long-standing debate, something I was going to address with you. But it's now accepted that there is such a discretion, and then in exceptional cases, even though a ground for setting aside has been made out, you may exercise the discretion not to set aside. Now, I would accept that if a court of first instance is exercising that discretion, perhaps one ought to be more slow in going the other way. But we are not in that situation. We are at the stage of trying to understand whether one of the grounds of Section 39(2) has been violated. And that is, we respectfully submit, a matter that is entirely reviewable by this court under Section 42 of the IAA.
There may be a degree of confusion here, that it's not unusual. Well, it is unusual, but it's not unprecedented for an appellate court to be faced with a contention that the trial judge, for example, mistakenly thought that a point had been conceded when it had not in fact been conceded by counsel appearing in front of him. And so the appeal court will look at, if there's a transcript of what was said, it will look at the transcript and consider whether, in fact, obviously it will normally, in practice, it would have a report from the trial judge and see what he thought, and it would form a view as to whether the question whether the trial judge had reasonably or indeed correctly found that the point was being conceded wouldn't raise an issue of natural justice. I mean, I can see that there's a point of natural justice if you argue that the conduct of a judge or an arbitrator was so oppressive as to have bullied counsel into conceding a point, for example. But at the moment, that's not the point we're looking at the moment. We're looking at whether a point was actually conceded or not. The arbitrator understood that it had been. The other counsel in the case understood that it had been, for that matter, as well. The Supreme Court has taken the view that it had been, having looked at the transcript. And at the moment, I'm inclined to think that that is a question of fact on which we have a very limited scope for interfering.
My Lord, if I may, I think there are two questions in your question, perhaps, and let me explain what I mean by that. On the one hand, you're saying that there may not be a breach of natural justice when you have an incorrect decision as to whether a concession was made or not. Now, my Lord, that may be the case in court. I can show you, and maybe now would be the time to show you, authorities which clearly show that in the context of arbitration, where an award does not deal with issues that were live, it is liable to be set aside. Now, there's a difficulty that arises under the model law, which my learned friends have been prompt to latch on, in that there is no express wording dealing with that as a ground for annulment, awards infra petita. And you can contrast that with section 68(2)d of the English Arbitration Act, which has that ground. But that is a mistaken...
It must come under section 39 2B4, mustn't it?
Indeed,
breach of the rules of natural justice.
Indeed.
And it only runs if such breaches is demonstrated causes substantial prejudice.
I will come to that, my lord. In fact, I hesitate, my lord, because I'm in your hands as to how you will be assisted.
Well,
but I think
we've made it perfectly clear that it strikes us as an important question whether the issue was in fact live at all,
yeah.
and that that essentially turns on the transcript on which we have the views of the arbitrator and the views of, well, we know what the arbitrator made of what was said to him, and we know what the Supreme Court made of the transcript. Now, I don't think there's much point in our pursuing that matter any further, because you know we've heard what you have to say on that, and really Section 39 kicks in on the hypothesis that there was a live issue which wasn't dealt with.
It does. One has to first obviously establish the fact, but my lord. On the question of fact of how one reads the response by Mr. Chetty, respectfully submit, it would be unfortunate if a party should be found to have conceded the entirety of its case in a situation where, at the very least, the wording on the transcript itself is not clear, and when you have correspondence which is inconsistent with such a concession having been made. My lords, we really, I do hear what you say, but we would ask you, obviously, given what you have just said, my lords, I was going to take you, because all this has to be informed by the way in which the matter has been pleaded. And then you see what is actually being argued, and then you see the intervention, and in context you see the response. Now, we have done that exercise in our written case. I was hoping to do it with you this morning, because really when you see it in the way it has evolved, we respectfully submit you will have a different picture than the one you came to, simply reading that one sentence, which is picked up in the judgment, picked up in the award, and then picked up in the judgment. And again, you have to read this in the context of, is it fair that a party should be held to have abandoned the entirety of its case just on that one sentence, when there are a great number of surrounding circumstances that do not point that way? My lords, I think perhaps what I should do, given the indication from your lordships, is to turn to the question, which is effectively D2 in the structure which I handed out, which is the position if counsel for Vsoft in fact conceded the issues following the arbitrator's intervention. And I see my Lord Reed is still looking at the...
well, I'm just checking.
Yeah.
I see the letter that you rely on,
Yeah.
of the 14th of November. There was a reply to it, a response to it on the 17th of November by Peepul's lawyers, saying that the letter proceeded on the wrong basis and that it should have been under the shareholders' agreement.
But my Lord, they would say that, wouldn't they?
But I presume there was no further response to that on behalf of Vsoft.
No.
No. Right.
But my Lord, we're back in this question of where does one stop? Does one need to file a reply to the reply to the reply?
mean, just in terms of, you say the single sentence uttered by Mr. Chetty.
Yeah.
I mean, it can fairly be said, can't it, that he could have been in no doubt as to the seriousness with which his words were going to be treated at that particular juncture, because the arbitrator had called an adjournment specifically for him to take instructions on the position that his clients were going to be adopting.
It can fairly be said, my lord, that he has been put under intense and immediate pressure to say something. And that when he comes back, he says, my position is what it has always been.
Yes, thank you.
Yes, but I mean, if we were to say to you, if you want to take instructions on whether you really want to pursue this argument, I would expect you to take instructions. And if your position was you did want to pursue the argument, you would come back and say so. I mean,
Well, and then I would come back and tell you, my lords, I have changed my position. I would not come back and tell you my position is and has always been as follows. I would not come back and tell you the question arises of where we are in the implementation process, when normally the only thing that would arise, if truly I had conceded my whole case, is let's put $17 million and 15% in 2 cells in an Excel spreadsheet and press the enter key.
right.
Mr. Mullen, this issue arose in the first place because the arbitrator was having difficulty in understanding what the submission was. There was an adjournment to enable him to take instructions. Surely that was the appropriate point at which to make a clear and concise summary of what the position was. Instead of that, we get what appears to be a concession.
My lord, I think if we now, and again, bearing in mind the indication from your lordships, if we look at the intervention now, but perhaps putting on the glasses of a breach of due process because of the intervention, I would respectfully beg to differ with the characterization you've just made of the intervention, which is that it's because he has difficulty understanding the argument. I think the intervention itself, in fact, is based on a great number of misapprehensions, which point to this arbitrator not listening with an open mind. Perhaps we should turn to that.
Do you want us to look at that?
Yeah.
Yes.
My lord, if you just give me one moment.
825, thank you. I'm grateful to my lord. At the top of 825, we see I have difficulty following your submission, however attractive it is.
I understand, my lord. I know he says that.
So in terms.
I do understand, but perhaps if we look at what he then says...
But you see, what I find, so we go on about this, but you were able to encapsulate earlier on today in a sentence what the issue was, as you understood it, i.e. was it 17 million under the shareholder agreement or 8 million under the other agreement? Now, if Mr. Chetty had said that's the issue, everyone would have known where they were.
Well,
But instead of which, he says the claim is admitted.
Well, you may say it was an issue because it was one of the issues raised in the arbitration.
Yes.
But I still don't understand what the case was under which it could possibly be argued that the investment agreement was still in force and applicable to define the amount owing.
my lord, you will remember, because we are focusing on this question of the investment agreement. There's also the separate live issue of where we are in the implementation process, which is linked with the shares. Let's focus on
that is fairly and squarely under the shareholders' agreement.
It is under the shareholder
Yes.
agreement, but it entails deciding where we are in the implementation process. So,
that may be so, but help me on the investment agreement.
but my lord, before we
before
leave that question of the shareholders agreement, where we are in the implementation process could also have an impact on interest, for example.
But it wouldn't lead to it being X million plus interest from the date of the investment agreement.
Indeed, but it could still have an impact on it would have two impacts. One, it could have an impact as to the date from which interest was payable. And secondly, it would have forced the arbitrator to apply his mind as to what happened to the shares. And that question under the shareholders agreement, the implementation process, my lord, the very first step in the implementation process is the surrender and cancellation of the shares, which in fact never happened. And this is why Mr. Chetty is
Surrender
talking.
happened, but the cancellation may not have happened.
But because the position of Vsoft was that it was late
Yeah.
And then you see what happens is that Vsoft in August 2013 asked that there be a transfer to the promoters instead of to the company, and that is then refused by Peepul. So that's the position of the shareholders agreement. What you see under, to come back to your question, my lord, about the investment agreement, it's both parties, and then, of course, the claimants no longer pursue it. But perhaps one should remember or understand, I think, why the claimants don't pursue it. Both parties take the position at various points in time that because the process is not being followed under the shareholders agreement, because there's an accrued rights provision under the investment agreement, could we be in a position where the claim would arise under the investment agreement? But they were drawing very different conclusions from that. In the arbitration agreement, the funders were saying, well, if we fall back on the investment agreement, you owe me $56 million. It was then pointed out to them it's a best endeavors obligation, not a requirement, and that then is dropped. Whereas in its pleadings, what Vsoft is saying is that under the investment agreement, you would only be equity holders, you're entitled to nothing. And the ultimate position which Mr. Chetty is adopting is to say, well, the investment agreement cannot be extracted from the equation, the process hasn't been followed. And my lords, I accept. It is then difficult to understand how he's saying that, whereas earlier he was saying it's just equity, you're entitled to nothing, he's now, after the arbitrator's intervention, saying, well, we're prepared to pay, to refund the monies with interest under the investment agreement. But the issue was there. And the question is it open to an arbitrator to say, I will not decide the issue?
I'm sorry, but I still don't understand what the case is that the investment agreement was still in force. Is it a pleaded case? Do we find that in the pleadings?
It is, my lord.
Well, can we see that?
Yeah.
I mean, bearing in mind that after the surrender was tendered, there's a letter from Vsoft saying, we still owe you the money under the shareholders agreement.
My lord, but that letter is then followed by the letter by the request in August 2000.
Yes, well, there may have been a rejected request to do something quite different than the agreement contemplated. But on the face of it, a late tender followed by an acceptance of the tender and an express acknowledgement in writing that the shareholders agreement is still in force would appear, to my simple mind, to be bell, book and candle.
My lord, and if that had been the position which the arbitrator wanted to hold, one, it should have been pleaded as such.
Well, no, with respect, I'm looking for your case that isn't the position, bearing in mind that those appear to be the facts.
My lord, if you look at Vsoft's statement of case,
thank you,
which is at page 356 of volume 2. And at page 359. Yes.
Sorry, what document is this?
This is the so the way the pleadings work, my lord, is that you had a state, because there were claims and counterclaims. So you had a statement of case from Peepul, you had a statement of case from Vsoft, and replies by each party. And this is the statement of case from Vsoft. So it starts at page 356, and the paragraphs I'm taking you to are 23 to 27. Perhaps, my lord, if I could leave you to read those.
And should we perhaps also look at 25?
Yes, 23 to 27, my lord.
So the investment agreement is at 25 said to be terminated.
Yeah, with no accrued rights, so that's out of the picture.
Yeah. So I mean, your primary case appears to be the investment agreement has gone, paragraph 25. Yeah. Is there any alternative case that actually it hasn't been?
No, paragraph 27, my lord, you asked me whether the allegation was pleaded. The allegation was pleaded. If you look at the last sentence of 27, to all intents and purposes, therefore, 727720, which was Peepul's investment, was and still remains an investment made by people in the respondent company, and returns can only be recovered by means of dividends. So one can dismiss that case.
That's not an acknowledgement of a liability to pay.
No, my lord.
7.2 million.
My lord, if you remember the submission I made a moment ago, the way this worked is that both parties said the investment agreement, or rather the investment is still in place, the shareholders' agreement doesn't apply because the process hasn't been followed. The other side were taking from this that $56 million were going to be owed under the investment agreement. The pleaded position of Vsoft was no. The effect of that is that you're entitled to nothing. And at the hearing, there is a concession, and the witness also says that he's prepared to refund the amount under the investment agreement. My lord,
in light of paragraph 25, there couldn't have been any argument that 8 million might have been due under the investment agreement, because we're told that it has been terminated and there was no accrued right under that agreement which survived its termination.
My lord, does that allow the arbitrator not to decide that point, or also does it allow him not to decide the other point about the interrelationship of clauses 3 and 5, which are put to him?
Unless people were arguing that they had a right to payment under the investment agreement, which I don't think they were,
well,
there was simply no issue about it.
My lord, if you look at the arbitration agreement itself, which is the reference to arbitration, which is in volume 1 at page 21.
Well, we seem to be going back in a sort of an infinite regression. I mean, we've seen what was said in closing submissions, and to overcome the problem with that, you're taking us to the pleadings. When we look at the pleadings, which tell us the investment agreement is dead, you want now to take us to the arbitration agreement.
My lord, if I may, and if you look at the structure sheet which I handed to you, I was hoping to go exactly the other way.
But at the end of the day...
But you brought me to the end, and I'm going back to the beginning.
But at the end of the day, pleadings, and for that matter, the arbitration agreement, are simply setting the scene, setting the boundaries for what may be the areas in dispute. But what remains in dispute at the end of the hearing depends on the parties' closing submissions.
Well, my lord, pleadings define the issues, and particularly in arbitration. And we had this exact issue, and I was going to show it to you, but you probably have seen it. This exact issue is in the arbitration agreement.
But is it in the pleadings?
No. I absolutely understand that it is flagged up as an issue, right as the very first issue in the arbitration agreement on page 21. So an arbitrator will think, well, that appears to be flagged up at the outset. And so he goes to the pleadings, and both sides are saying, this is not a liability under the investment agreement, because people are saying it's been overtaken by the shareholders' agreement, that is still in force, and by the termination agreement, which says in terms that the investment agreement is over. And Vsoft is saying pretty well the same thing. The investment agreement is dead. So why does he think, when he starts to try and understand what Mr. Chetty is saying in his closing speech, that there is any issue about whether the investment agreement is still live?
My lord, let me be clear. The difficulty I have, and is the same difficulty which your lordships have, is that, and that is not true of the interaction between clauses 3 and 5 point, which I think has substance. On the investment agreement point, if I were to argue that point, I would struggle, and I make that clear. The question you're asking me is, was it pleaded? Now, my lord, not you yet, but many of us in this field sit as arbitrators as well, and we see case after case after case of bad points. It's never crossed my mind to say it's a bad point, therefore I don't need to decide it. Bad points need to be decided. And
if it's a bad point, why does its non-decision cause you serious prejudice?
My lord, the investment agreement, the investment agreement point is one of 3 issues which we say were live. the one issue which we have focused most on, my Lord, and I understand why you would ask me questions about the investment agreement, is the question of the interrelationship between clauses 3 and 5, which Mr. Chetty had relied on clearly in his pleadings, in his closing submissions, to say that there has been a failure by the funders to meet their obligations, and that therefore the obligation to pay had not arisen. So, and that issue is not decided at all. And this was, my Lord, the background.
Are we now moving away from the investment agreement? Because if it's a bad point, then I doubt if you would be expecting us 4 years after the arbitration award to use it as a reason to send the whole thing back.
But, my Lord,
but we're now on a different point with the clause 3, clause 5 point.
The two are linked, because you may remember the way in which Mr. Chetty was putting the point is that you need to decide which agreement you are under, and then what is the legal regime applicable to that agreement. Now, his overall submission was, this is what you ought to have done under the shareholders' agreement. It has not been done. And where there is a difficulty is that he then tries to get into a situation where he says, well, we're prepared to pay something. And that, I agree, is where things break down, because he has to fall back on the investment agreement. So the two are linked because he wants to fall down on the investment agreement. But the shareholders' agreement point, my Lord, was live. And that is something which could and has caused substantial prejudice, because he has never determined where they were in the under the shareholders' agreement, in the implementation process. And on a very basic level, this has an impact on interest.
But if you put the investment agreement on one side, and you understand from Mr. Chetty's submissions that there's only an issue about quantum, and if there really was a live, different quantum outcome that could follow from the clause 3, clause 5 question, you'd expect that different quantum to be spelt out in the subsequent letter from your clients. But it's not. All they do is put in a schedule that assumes that the investment agreement is still alive. They don't run an alternative quantum case based on some different interpretation of clause 3 and clause 5.
The letter, my Lord, goes, the post-hearing letter, goes to the question of whether there had been an overall concession of the claim by Mr. Chetty. And that letter is not consistent with there having been such an overall concession. If there hasn't been a concession under issue 1, which was live, there was no concession under issue 2 either. That's what the letter goes to. I agree, of course, the letter goes most directly to the investment agreement point. But I'm relying on it to say you cannot read the words of Mr. Chetty abstracted from the whole context, and particularly that letter which shows that those issues, all 3 issues, were live. Issue 1, which agreement applied? Issue 2, within the shareholders' agreement, what is the interrelationship between clauses 3 and 5, and where are we in the implementation process? Issue 3, which is necessarily determined as part of issue 2, what has happened to the shares? The shares are the very first step in that implementation process. So this, my Lord, is the submission. And when you say that the pleading, my Lord, is not a pleaded point, the conclusion at paragraph 27, which the arbiter certainly could dismiss and say he disagreed with, is not that the investment agreement is out of the picture. He says, for all intents and purposes, the invested amount was and still remains an investment, whereas Peepul's case was that the shareholders' agreement had converted it into debt. It's pleaded. It has to be determined. Again.
Well, but at the very least, Mr. Chetty is saying, actually, it's now a question of quantum. In other words, it's not a question of whether this is an investment or a debt. It is a debt. The question is how much of a debt? I mean, you can't read his concession as being narrower than that, can you?
But, my Lord, and just before that intervention, as I showed you, I think it was at page 825, he is describing, he's referring to the question of quantum as being where we are in the implementation process. He is. And he reiterates that in the response. My Lord, I was going to move to the intervention itself and a failure of due process simply by virtue of that intervention by the arbitrator. Right, so the intervention, my lord, starts at page 825. We were looking at it a moment ago. And we make the following submissions about it. Now,
Which page are we on?
825.
825.
my lord, if I may, sorry, my learned junior is passing me a note which I think is relevant. Just before we leave the question of the concession and what points were pleaded, may I show you one paragraph of Vsoft's reply, which you will find, if you just bear with me. The reply is at page 481. So that's the reply of Vsoft to Peepul's statement of case. And this is responding to paragraphs 8 to 11 of the claimant's statement of case. These were paragraphs, my lord, where Peepul was asserting that the tranches had become due, right? And that was the answer. As per clause 5 of the shareholders' agreement dated the 2nd of May.
I'm so sorry, where are you reading?
I'm sorry, my lord. Paragraph 17
Yeah.
on page 484.
Oh, yes.
So, my lord, paragraphs 8 to 11 of the claimant's statement of case. Just for your reference, you don't need to go there, but if you want to look at it, you can annotate your page, or at page 264. And these are paragraphs which allege default on the tranches. But I see my Lord Sales is going to that, so if you look at that briefly.
With a flag in, in fact.
Yeah, page 264. If you see paragraph 9, so this is a pleading under the shareholders' agreement. Paragraph 9, first sentence, allegation that $10 million were not paid, and that's a default. And paragraph 11, allegation of a default on the $5 million. Turn back to paragraph 17. You see, these are denied. As per clause 5 of the shareholders' agreement, dated the 2nd of May 2012, the set of actions to be done by the respondent is subject to the claimant's initial compliance with their part of the obligation, that is surrendering all but one equity share. However, it was only on the 8th of October 2012 that the claimants actually surrendered the share certificates as per the shareholders' agreement. And my lords, just for your reference, in the agreed statement of fact and issues, at paragraph 18.3, that's page 1755 of the record, it is the agreed position of both parties, I quote.
Sorry, paragraph?
Sorry, in the statement of fact and issues.
Yes, which paragraph?
Paragraph 18.3.
Thank you.
At page 1755. You can see this express quotation from 17, and I draw your attention to the agreed last sentence of paragraph 18.3. For this and other reasons, Vsoft denied being indebted to the respondent in the sum claim or at all. So, and that, my lord, is the question about the implementation process under clauses 3 and 5. My lords,
So the issue there is, as I understand it, because the implementation's gone wrong, we're not liable for a penny under the shareholders' agreement.
And by the time Mr. Chetty responds, he's saying, well, we are agreeable to pay something, but we are in your hands as to where we are in the implementation process. So the arbiter on that submission had to make a finding as to the interrelationship between clauses 3 and 5, which could lead to a number of things. It could lead, for instance, to interest being payable only from the 8th of October 2012. It would certainly lead to findings as to what had happened to the shares. But what is not open to an arbitrator when you have a pleaded issue, which is the issue of where we are on the implementation process, which is on any view, my lords, on that reply, maintained, then not to decide it. My lord, perhaps if we go back to the intervention, and I was going to give us our points as to why we respectfully submit that intervention was objectionable and a failure of due process. If, as it would seem, my lords are prone to find, it caused a concession. Now, the first point to note, we say, is that the arbitrator appeared to place particular weight on the two letters which were written by Mr. Viraganta in November 2012 and by his lawyer in May 2013, which are at pages, for your reference, 731 and 732 of the record. I don't suggest we turn to that now. He referred to those at the beginning and at the end of his intervention. And you will see from page 8 to 8 that he is not saying, because that wasn't a pleaded case, that those letters had preclusive effect. There was no allegation by the funders that those two letters, lords, had preclusive effect. And if you look at them at 731 and 732, the Supreme Court only referred to those letters as part of the factual narrative in 6 lines of the judgment, and that's, just for your reference, volume 3, page 1046, lines 10 to 15. And we say that's correct. It wasn't submitted during the arbitration that they should have any form of preclusive effect, nor any finding made that they did. And they must also be read, my lords, in the wider context of what was going on at the time. The shareholders' agreement, my lords, is signed on the 2nd of May 2012. Under clause 5BB of the shareholders' agreement, a promissory note securing tranche 1 for $10 million was to be issued following the surrender and cancellation of the equity shares. Yet the promissory note to Peepul was issued the very next day, the 3rd of May. The shares themselves are then only surrendered on the 8th of October. And if you have read, you will see from our written case, it's very clear from the evidence of the witness of Peepul that this was done by design and not inadvertence, because he says we wanted to hold on to the shares in case funding was not forthcoming within the company. So here is a party that has, it tells the arbitrator, agreed to convert its equity into debt, but in fact holds on to that equity in order to see what is going to happen, rather than comply with the agreement, which says surrender your equity and get your debt. This is what was happening then, and we submit, as you will have seen from our submissions on the injunction, is still happening now, which is that they have got an award enforcing their debt, but yet...
Paragraph 2 says that the share certificates have been received, and we have initiated issue of shares along with the debt notes as mentioned in the agreement.
Well, which then never happens.
But Vsoft is waiving the breach, isn't it?
My Lord, by one, there was no claim of waiver in the arbitration. Again, these letters were simply not relied on in the arbitration as having preclusive effect. So it wasn't open to the arbitrator to find that. And if he wanted to find that, he would have had to put it to Vsoft. And if we go back to the arbitrator...
Sorry, I mean, surely the arbitrator wasn't saying these letters have preclusory effect, but they cause him to question what exactly your client's case was,
yes,
which is precisely the question that he put to Mr. Chetty.
Yeah.
He's saying that those letters go to credibility of what Mr. Chetty is saying, and you find that from page 827. These letters negate the submission. I personally consider, it seems that the question of sincerity and credibility is very much at the center on page 828.
Yeah. Well, it's unsurprising when you see the letter on page 732, what's said there. I mean, this is written on behalf of Vsoft, saying that it has all the intentions to honour the terms of the shareholders' agreement and will pay the amount due to your client under the shareholders' agreement. And the rest of the letter is explaining they're trying to get the money together.
My Lord, and this is then followed by two events at least. One, that in August 2013, Mr. Viraganta requests, which would be inconsistent with this being a waiver, that the funder's equity shareholding be transferred to him. And they are, of course, then followed by Vsoft's formal position in the arbitration, which I have showed you. So if the funders had wanted to argue in the arbitration that those letters precluded Vsoft from denying liability, they would have had to do so, and to explain as a matter of law why they should have such an effect. And the absence of such a plea would not have been open to the arbitrator to make such a finding. And even if one ignores that point, if the arbitrator had been minded to find that it was not open to Vsoft to raise the defenses it was raising on the basis of those letters, then that's something which he would actually have had to do in his award, analyzing the contemporaneous documentation and the document said to contain the admission and explaining as a matter of law why they should have such a preclusive effect. And he didn't do so, my lords. If we go back to the intervention, and if I may continue with the points as to why we say that intervention was objectionable. You see that the arbitrator makes a number of points as to, and because that was the gist of Mr. Chetty's submission, was the interrelationship between clauses 3 and 5 of the shareholders' agreement. And Mr. Chetty is therefore, Mr. Domag is the arbitrator, is therefore himself now making a number of points as to the interrelationship between clauses 3 and 5. With respect, we submit that it is not easy to follow what those points were. And the way we would put it, my lords, is that they appear to boil down to a view that because clause 3 preceded clause 5 in the agreement, the obligations under clause 3 could not be subject to those under clause 5. And I draw your attention to the following passages. On
I don't think he was simply talking about precedence textually. I mean, I think what he's saying is that 5 has to do with the completion of arrangements which are triggered by the payment of the tranches in accordance with clause 3. And because that hadn't happened, clause 5 arrangements didn't actually arise.
Well, I think it would be useful to look at clauses 3 and 5 before we continue with that, so I'll do that. But I would just point out that the way he's expressing it is, if that's what one is to understand from that, wonderful. But that's not what he's saying. He's saying this is why clause 3 precedes clause 5, as though clause 5 ought to have preceded clause 3. And you see something similar at page 827, about around the middle of the page. It would be about, I would say, 15 lines down, a sentence starting, and this is why Article 3. I'm sorry, but we don't understand this. This is why Article 3 comes prior to Article 2, because then you must read Article 4 before you read 5. So that's a wonderful way of reading a contract. Let's look at the contract, if I may take you to that, which is at volume 2, page 321. So the funders pleaded position in the arbitration that the effect of this contract was to effect a conversion of their equity into debt. So obviously I would ask you please to look first at clause 3, which begins at the bottom of page 326, exit obligation. And this provides in its chapeau that the company and promoter group shall procure the exit of the investors of their entire shareholding in the company for an aggregate sum of $17 million, plus a return on the second tranche minimum payment and third tranche minimum payment as per section 3D, plus an XIRR of 15% on the shortfall amounts from the due date as detailed in section 3E, on the terms specified in this agreement. Now, my lords, that is not consistent with one abstracting clause 5 from the matter. It's not consistent with saying you read clause 2, then you read clause 3, then you read clause 5, then you read clause 4. Then you have the three tranches, 3A, B, C, clauses 3A, B, and C, three tranches of $10 million payable by the 31st of August 2012, $5 million by 28th of Feb 2012, $2 million by 31st of August 13. The effect of 3D and E, it's a bit convoluted, but the net effect of these clauses was that the interest rate of 15% XIRR was to be paid on every tranche from the 1st of September 2012. Now, if we go to clause 5, having just defined in clause 3 the exit obligation, you move on to the exit steps. The chapeau says that the parties shall do all acts necessary to ensure the completion of investor exit and shall ensure to take the following steps in addition to all other acts or deeds necessary for the completion of investors' exit. So again, that is not consistent with clause 3 being read in abstraction from clause 5. Clause 5 is implementing clause 3. Clause 5A is obviously the first step, which is that the investor shall surrender on a business day, the surrender date, all the investor equity shares except one equity share back to the company for cancellation of such share certificates. Upon receipt of the surrender shares, the promoter group agreed to and to cause the company to complete the cancellation of the surrender shares within 3 business days from the surrender date. Then 5B, next step, upon cancellation of the investor equity shares on the cancellation date, the promoter group agreed to and to cause the company to initiate and contemplate all the necessary corporate actions to issue the following to the investor. And what you then have at A is a convertible share which would be converted into a share giving voting rights in case of default. And you find that in Schedule 5, which for your reference is at page 355. Under B, a promissory note securing the first tranche of $10 million. Under C and D, 2 redeemable preference shares in the amounts of the second and third tranches. And then 5C provided for certain changes which were to occur to the board upon cancellation of the equity shares. And my lords, we respectfully submit that on the face of clauses 3 and 5, it is, and we put things at their very lowest, it is at the very least arguable as a matter of contractual construction that the surrender date and the cancellation date stipulated in clause 5A must predate the payment obligations under clause 3. Clause 5B, which is triggered by cancellation of the investor equity shares, puts in place security for a debt which will arise under each of the 3 tranches provided for under clause 3, including security which will be, in the future, converted into as and when default occurs under clause 3. Now, we respectfully submit that this is consistent with the intended steps being 1, surrender of the shares, 2, cancellation of the shares, 3, issue of the security concomitantly with the cancellation, and 4, later automatic conversion or ability to enforce the security once the various tranches fall due. And my lords, this is also consistent with the funder's case in the arbitration that the shareholders' agreement effected a conversion of their equity into debt. That debt would, of course, arise upon surrender and cancellation of that equity, not before. So, my lords, with that in mind, if we can please go back to the intervention of the arbitrator. Which is at page 826. And you see, I showed you 2 passages already on page 825 and page 827, which we respectfully submit do not show a grasp of the contract. There's another passage at page 826, from the 3rd line from the top of the page. I fail to understand how Article 5, the exit steps, can come into play prior to the fulfillment of the exit obligation under 3. We say that is manifestly wrong. And then, my lords, the arbitrator was operating under a very significant mistake. If you look at page 827, he says here at page 827, I cannot help noticing that under the investment agreement, which now your client agrees to abide by, so I pause to note that clearly he understands that that is the case of Vsoft, that it is saying it's ready to pay under the investment agreement. The obligation was much more than, and that's a typo, it should be $70 million US. This has been reduced precisely to assist your client and presumably at his request. Now, my lords, it would have been obvious to anyone going through the pleadings, as we have seen, and it had been an important part of Vsoft's case, that there had been, of course, no obligation under the investment agreement to achieve a particular return. There was a best endeavors obligation, not a commitment. The arbitrator seems not to have appreciated this, again, despite it having been the subject of pleading, evidence, submissions before him. And we respectfully submit that you should infer from the arbitrator's comment that he was approaching the dispute on the basis that entering into the shareholders' agreement had financially benefited Vsoft because it had reduced the sum of money that it was to be paid, and that this had been at its request, and that this view of the commercial dynamics colored the arbitrator's approach to the case. It also likely explains, we submit, my lords, why the arbitrator did not realize, because we submit he did not, when he received the letter from Vsoft after the hearing, that those calculations were based on the sums invested at the time of the investment agreement, and were consistent with Vsoft's case that payment was due in connection with the investment agreement. Now, all this, my lord, was expressed in very strong terms and concluded with an express request that Mr. Chetty seek instructions from his client as to whether it would be possible to pursue that strategy. Now, in our submission, that formulation, as well as the overall tone of the interjection, leaves, in our submission, no doubt that the arbitrator did not hear Vsoft's closing submissions on the questions of which agreement applied and of the interpretation of clauses 3 and 5 of the shareholders' agreement, if that agreement did govern, with an open mind. This was with respect an improper attempt to force Vsoft to withdraw an aspect of its case, and we say again, on a wrong premise as to the construction of clauses 3 and 5, and on a wrong premise as to the effect of the investment agreement. And my lord, that is precisely why one should not intervene in this way. You listen to the submissions, you may disagree, you sit down in a room with the pleadings, with the contracts, and you make a determination.
Well,
Instead-
as you may have noticed, some judges rather like to put to counsel other ways of looking at the problem from the one that counsel is advancing, and as either to test the argument or because they're simply being candid about the way they see the argument at that stage. This arbitrator keeps saying, this is the way I see it for the time being.
Yeah.
I don't know what you refer to. It's never happened to me.
Some counsel even find it helpful if the judge
My Lord,
indicates his view.
My Lord, it depends. It depends how it's done, with respect, and of course your lordships will be very aware of how one does it.
But he does keep. I'm right, I think, in saying that he keeps saying words to the effect of, "This is how I see. This is my view for the time being."
Yeah. Top of 826.
Also, 827 line 7, and again on 827 second last line.
And my lords, and then to say, go and seek instructions to see whether you should concede your case, rather than please explain your argument to me? Because that is his conclusion.
Well, he's obviously finding difficulty in understanding what the case is, and he's saying how he sees it, but he obviously also sees a certain degree of inconsistency with the case that has been put in the previous letters. So, I mean, there is an issue, as he says, sincerity and credibility, but he's very fairly putting his concern about that to counsel. Counsel has the chance to come back and say, you've got it all wrong.
My Lord, to put these points, and I would respectfully submit one would not put this in a passage which must have gone on for about 5 minutes. But one could break out points and say, well, can we look at clauses 3 and 5? I don't follow what you're submitting, for example, and ask for submissions. What is being done here is an arbiter very forcefully putting across to counsel that you have to take instructions. I'm not sure whether you can pursue that strategy. Now, you have seen...
The trouble is, you've shown extremely well, if I say so, how counsel can respond to somewhat hostile interventions from the bench.
Hostile, my Lord?
Well, the last person suggests that, but certainly. Now, it's fair to say none of us, I think, have gone on for 5 minutes, but... And the Supreme Court, who presumably know Mr. Chetty, they know the situation, I don't know, seem to have been quite satisfied there was nothing untoward in the way he was dealt with by the arbitrator. And I don't see how we can think that somehow Mr. Chetty, I mean, if you come back to the point, I seem to be saying he was cowed into submission, rather than coming back and saying, well, no, you've got it quite wrong, sir.
Well, my Lord, and maybe we should look at the test, and we have given you, because I think there's an assumption here, and also there certainly was an assumption by the court below, that one simply reproduces in the arbitration hearing room what one reproduces in a court hearing room, and I'm not sure that's a valid assumption. And I take that on the authority of, as you know, of Lord Mustill and Stuart Boyd, QC. And if we could just briefly look at that authority, which you will find in the authorities bundle. Tab 27.
And can you give me an electronic page?
Sorry, 2416.
Thank you. 241?
2416.
Thank you.
That is simply the cover page.
Yeah.
And you see if we are relying on Roman 5 on page 2417. And this is what Lord Mustill and Stuart Boyd QC say about the practice of stopping counsel. A particular form of intervention by the arbiter which merits separate discussion is that of stopping counsel, which is used by arbiters less than it might be. It involves indicating to a party's advocate that the arbiter has accepted a particular submission and proposes to rule in his favour on it. Its chief function is to avoid the need for a claimant to take up time in his final speech on a point on which the arbiter is in his favour. But it may also be used during the claimant's or respondent's opening in order to indicate that further argument is unnecessary until the other party has been heard in reply. It should be used more sparingly in this situation, since it may turn out on hearing the other party that the point is less easy to decide than appeared at first sight. The practice of stopping counsel is a useful one, but it should only be used when the arbitrator's decision is in a party's favour. It should not be used as a way of cutting short a long-winded argument when the arbitrator had decided against the party making the submission. To stop counsel in this situation and then to decide against his client might well amount to misconduct. The best course in this situation is for the arbitrator to summarize in his own words the submission which is being made so as to indicate that he has understood it, even if he does not necessarily agree with it. Few advocates will go on repeating themselves once they are sure the point has been understood.
But if they do, surely the arbitrator is entitled to stop them.
Well, my lord, you again, this is on the authority, I think, of two practitioners who have been practicing in arbitration, or Lord Mustill, of course, is no longer with us, but had been practicing in arbitration for a long time. And one has to understand the rationale for that rule. Because the Supreme Court below said, oh, well, pressure. And again, my lord, you put the question to me on the basis that there has to be pressure applied. But it's not a question of pressure, my lords. It's a question of allowing, as is the statutory duty of arbitrators under the Mauritian Arbitration Act, as under every modern arbitration legislation, allowing parties a reasonable opportunity to present their case. And on that, the reason it's not about pressure.
I don't think we need to go into it, because the counsel was not stopped. He was asked to, he was afforded an adjournment in order to give him an opportunity to take instructions.
We would say, my lords, that's worse than being stopped in a way, because his argument certainly is being stopped. Sorry, my lord, what I mean by that, let me explain myself. One practice which one could understand, and I think my Lord Reid was referring to it, is to say, well, let's look at the clauses. I don't follow your argument. And to cause counsel to then explain his argument by reference to the clauses, for example. And therefore inviting further submissions. Another practice would be to stop altogether. What we have here is something altogether different. He stopped, and he's being told, please go out of the hearing room and go and consult with your clients, not to formulate a response, a responsive submission, but he wants that instructions be taken from the clients. What purpose could there be for that, other than to hopefully come back and concede?
Well, doesn't he explain the purpose? I mean, he says, to the extent that I understand your argument at all, it appears to be directly in conflict with two letters written by your clients on advice, which appear to point precisely in the opposite direction. In those circumstances, might it not be a good idea, since credibility and reputation are at stake in all this, just to go back and consult with them about it? And the arbitrator seems to be taking the view that the pursuit of the argument might lead to the conclusion that the clients weren't being sincere in their earlier letters to which he's referring. And it would be a natural thing, wouldn't it, in those circumstances, to invite counsel to check with his clients that they're happy that he proceeds with the argument.
My lords, with respect, we say that is a very generous reading of the situation when one bears in mind that the client himself had been cross-examined, had given evidence that he was prepared to pay under the investment agreement, and had explained his admission of liability as being an admission of liability under the investment agreement. And my lords, at the end of the day, my submission is somewhat hampered by the fact that one can decide to adopt a generous view of all of this and to say, oh, so what? But oh, so what? Oh, so what has led to, supposedly, the concession of a $22 million claim? Oh, so what as well on Mr. Chetty's response? Let's just read one sentence. We say, my lords, with the utmost respect, this is not fair. A party does not throw away his case in that way. An arbitrator should not stop counsel in this way and then give his own views on the contract which bear no, which do not relate to the actual wording of the contract, and then ask counsel to go away and take instructions in the hope that this will cause for an abandonment of the case. That is not how arbitration should work. And in fact, my lords, this all matters. Because if the arbitrator had sat down in a room and had looked at the pleadings, and I know we have spent a lot of time talking about the investment agreement point, but the clause 3, clause 5 point, my lords, is by no means an easy point. It's a point he ought to have decided. And even if he had been against my clients on that, so be it. He would have had to express in that award, by deciding that live issue, what the fate of the shares was. It was clear on the record that the shares had not been dealt with as ought to have been the case under the shareholders' agreement. That question was put to him. Where are we in the implementation process? And he doesn't do that. So, my lords, with respect, especially on the concession point, if you have to read this with generosity to a party, it cannot be to the other side. You cannot, one can only concede an entire claim of $22 million in the clearest possible way, with the clearest possible words. And my lords, you've seen clauses 3 and 5. They simply do not tally with what the arbitrator was saying. And even on quantum, let's say just on quantum. And I go back to the point I was making earlier, my Lord Briggs. Clearly, the clause 5 steps are such that the debt could only arise once the shares had been surrendered. How can this award, in those circumstances, award interest from the 1st of September? Just that point. Just that point. And also, I'm going to show you now, if I may, perhaps just to summarize on some of the points which we rely on with respect to the intervention. We rely on the extraordinary length of the intervention, the express request at the end of the intervention that counsel take instructions to see whether he would concede the case. And we say those words can't be interpreted in any other way. I personally consider that you should seek further instructions from your client as to whether it would be possible to pursue that strategy, i.e. go away and tell me whether you concede the case. Thirdly, chastising counsel for purportedly not having put a point of construction of the contract to a witness. I haven't showed you that passage, but if you look at the intervention again, you will see it's being put to Mr. Chetty, but you didn't put that to the witness, a point of construction. The manifest errors within the intervention, which one would hope would have been mitigated by the arbitrator actually sitting down with the pleadings and the evidence to properly consider the point as part of the process of writing his award, including the 2 points we've covered, which is expressing a strong opinion against the construction put forward by counsel on the basis that clause 5 comes after clause 3, and not realizing that there wasn't a higher sum due under the investment agreement than under the shareholders' agreement. Now, my lords, we say that this is cause for annulment of the award under 2 statutory bases, and you have section 39 either in the handbook, which we have given you, or it's at page 2390 of the authorities bundle at tab 20. And there are two grounds for such a failure of due process. You have the ground which my Lord Briggs identified, which is 39.2b4, a breach of the rules of natural justice occurred during the arbitral proceedings or in connection with the making of the award by which the rights of any party have been or will be substantially prejudiced. Now, my Lords, I'm going to deal in a moment with the question of discretion, and together with it, with this question of substantial prejudice, and show you that the bar is actually quite low as to what substantial prejudice would required. And I will also show you in a moment, B4 is an addition to the model law. Actually, if we can look at that quickly, if you just...
Forgive me, Mr. Muller, you said there are two bases. One is 39.
Sorry, let me identify the two bases, yes. So 39.2b4, and the other one is 39.2a2, second limb. It was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present its case.
Thank you.
I apologize, but I should have completed that. The reason I was focusing a little bit more on B4 is because we have this additional element of substantial prejudice only for B4, and I was just going to show you, my Lords, if you turn at tab 21, which is page 2397 of the record, the explanation which we gave when enacting the legislation as to why we added B4, which is not in the model law itself. And it's explained as follows at paragraph 130 at page 2397. So it's the next tab, my Lord. One minor modification to Article 34 has been made to clarify that the right of recourse lies where the making of the award was induced or affected by fraud or corruption. That's not the point, but or where a breach of the rules of natural justice occurred during the arbitral proceedings or in connection with the making of the award. See sections 39.2b3 and 4. And we know that this is in line with modifications already made in Singapore and in New Zealand. So I draw your attention to the fact that these are expressed to be clarificatory amendments. Now, if we go to section 24.1 of the Act, which is at page 2376, you see that this sets out the crucial duty of the tribunal under 24.1a to give the parties a reasonable opportunity of presenting their case. And we respectfully submit that that duty was breached, and both those limbs of section 39 are engaged. And we emphasize again that with respect, the test is not a subjective one of pressure. The test is that of the fair-minded observer. The test is an objective one. And obviously, within the arbitration context, as much as in every other context, justice must not simply be done, it must be seen to be done. And if you need a quotation for this within the arbitration context, you have it from a Singapore authority of So Beng T, and I will give you the reference in a moment, where the familiar passage from Sussex Justices is quoted. So we say that your task, my lords, is to look at that intervention objectively and as a fair-minded observer would do, and see whether Mr. Chetty was denied a reasonable opportunity of putting his case, bearing in mind, my lords, that we respectfully submit the right approach is that put by Muscle and Boyd. And this, the Sussex Justice's quote you will find at page 2271 of the record within the authority, which is at tab 15 of the authorities bundle, so Bengti. Now, my lords, I move to the question of discretion. If we go back to section 39, you will see that under section 39.2, which is at page 2389, the chapeau has the word may. An arbitral award may be set aside by the Supreme Court only where, and then we have the various grounds that we have been looking at. Now, it is common ground, my lords, that this gives rise to a discretion not to annul where a ground is otherwise made out. There has been, as you may well know, my lords, a long-running debate between early commentators as to whether the word may actually imported such a discretion. And that debate took place more actually in the context of the New York Convention than in the context of the model law, which came later but adopted the same wording as Article 5 of the New York Convention. So quite a few early commentators said, well, no, these are supposed to be the grounds on which you annul, and one understands why one would use may, but may here is meant to mean shall. And there was quite a lot of linguistic comparisons, as you can imagine, between the various versions of the New York Convention and then of the model law. But I think it's fair to say today that that debate has settled and that a discretion does arise. May means may, and the question is therefore, what is the relevant test? My lords, if I could show you the judgment of Mrs. Justice Chan in A and B, which is a Hong Kong authority. In my notes, I was hopefully noting that normally would already have seen that, but we didn't go to the infra petita point. We rely on this authority if you change your minds and felt that, bearing in mind what I've told you about a concession needing to be, we submit, unequivocal, and that there was no concession and the issues were therefore live and not decided. This is a case, A and B, which is at page 1942 of the record, tab 1, is fairly and squarely a case from a model law jurisdiction which tells you such an infra petita award ought to be annulled. And she does so under the public policy ground.
Sorry, which is the part you want to look at?
On discretion, my lord, if you go to paragraph 11 at page 1945. So she's setting out the relevant tests, and she says, it is also clear that even if the grounds for setting aside are sufficiently made out, the court may nonetheless enforce the award as a matter of discretion. The grounds set out in Article 34 are only grounds on which an award may be set aside. And she says in the context of New York Convention and in the context of model law, the Court of Appeal emphasized that, and she quotes from Grand Pacific Holdings, an error would only be sufficiently serious if it has undermined due process. Even so, the court may refuse to set aside the award if the court is satisfied that the arbitral tribunal could not have reached a different conclusion. Could not have reached. How a court may exercise its discretion in any particular case will depend on the view it takes of the seriousness of the breach. Some breaches may be so egregious that an award would be set aside, although the result could not be different. So we say a low bar, and you see that applied by Her Ladyship at paragraph 34. And this was a case, my lords, where the arbiter wrongly believed that the limitation defense had been conceded when it hadn't. And she says this about halfway down through the paragraph 34, based on what was set out in the reasons for the award and the materials before the tribunal, it cannot be said that it is plain and obvious or beyond any doubt that the award would have been the same if the limitation defense had been considered. And we say, particularly, my lords, when you think of the Clause 3, Clause 5 issue, just the interest point, but also the where were we in the implementation process, and therefore what was the fate of the shares, that is clearly fulfilled here. And she goes on, this is not a case in which different defenses are raised, any one of which would have defeated the claims made, such that the failure to deal with any one of the other defenses would not have made any difference to the award. If we could look at another Hong Kong authority, which is China Property Development against Mandacley, and that's at tab 5 of the authorities bundle, page 2028.
I'm so sorry, I missed the page number. Page
I'm sorry. 2028.
Thank you.
And I would draw your attention to paragraph 7.4, which is at page 2038. There's reference to the authorities, and then the court summarizes. This is a Court of Appeal decision I should have made clear. I apologize. And I draw your attention to the sixth principle on page 2040. The court has a discretion not to set aside an arbitral award even if a violation of Article 34(2)(a)(2) of the model law has been established. But this discretion should only be exercised where the court is satisfied that the outcome could not have been any different. Put in another way, the party seeking to set aside the arbitral award does not have to show that the outcome would have been different had there been no violation of that article. It suffices for that party to show that the outcome could or might have been different. So, my lords, we respectfully submit that the test is satisfied here. We say that had the arbitrator properly decided the live issues, if he had sat down with the pleadings, the contracts, and the evidence, instead of, with respect, going on a long extempore dressing down of counsel for Vsoft, he might have realized, for instance, that the answer to the submission which counsel was making as to the interrelationship between clauses 3 and 5 did not lie in the fact that clause 3 came prior to clause 5 in the document. And even more importantly, he would have had to state clearly, and again, that was something which was requested even after the intervention by Mr. Chetty, he would have had to state clearly, I quote, where the parties were in the implementation process under clause 5, and thus what the fate of the equity shares had been. Now, the outcome might have been different on the interest issue, certainly on the fate of the shares. And that is all I have to show.
Can I ask, one of the points made by the arbitrator in the intervention at the very end of 827, top of 828, is that the way you are putting
if you
the
would
case...
bear with me, my lord, I apologize.
I'm sorry. I'm sorry, I'll wait for you to
Thank you.
find it.
827, my lord.
Yes, in the foot of the page, you see, he says, this is the way the case is being presented in the course of the claimant's presence. The way you're putting it now has not been put at all to the claimant. The claimant would have reacted to it. Now, I see, looking at the pleadings on behalf of Vsoft, which are at 356 to 360, the argument that nothing is due under clause 3 because there's been a failure to comply with clause 5.
That's in the other pleading, my lord. It's in the reply. You're looking at the statement of case here. It's paragraph 17 of the reply,
Right.
which is at page 484.
484. Okay. Thank you very much.
And my lord, on this passage, we say two things. One, it's not correct. If you look at the cross-examination of Mr. Venu Rao, the point to him about clause 3 and clause 5 and the late surrender of the shares. And to the witness, all that one has to put is you surrendered the shares late. That's the only factual point. And this is why I was saying to dress down counsel on the basis that he hasn't put a point of construction to a witness is wrong.
So was the suggestion that time was of the essence? So if you were late in providing the shareholder certificates, there was no obligation to pay anything?
Yes, my Lord. The suggestion was, I'm not sure it was put, well, it wasn't put on the basis time is of the essence. It was put on the basis that clauses 3 and 5 have to be read together, and that where there has been a failure to comply with clause 5, this was, to put in the words of Mr. Chetty, a situation of legal imbroglio, which had to be resolved. And which had never been resolved. And one can see from the factual situation, of course, one can look at those letters at 731 and 732, but you cannot forget what then takes place. The parties then, there's then a dispute. The letter at 731, for example, is written well after 31st of August 2012. And it says, we are going to pay as per schedule. As per what schedule? And then what happens is that in August 2013, there's still a dispute between the parties as to what is to happen to the shares. Do you transfer to us, etc.? But also, I don't want to get into that, but the background to all of this is, of course, that under the Companies Act, for a company to purchase its own shares, it must pass the solvency test. So that is, we can come to that. I'll come to that when we come to public policy. But these exchanges are not taking place in a vacuum. The company cannot simply take back its shares. There are certain statutory conditions as to when and how it can do that. But the overall factual position was one which in fact was a factual and legal imbroglio. Neither party had done what was expected of it. Vsoft, rather than wait for the cancellation of the shares, for whatever reason, issues the promissory note the very day after the agreement is signed. And then we have Peepul only surrendering the shares on the 8th of October. So again, to answer your question, I'm not sure the submission was time is of the essence, but the submission is the mechanism has broken down. The mechanism contemplated by the parties had broken down.
Can I just find out, as a matter of fact, it's common ground, isn't it, that people surrendered the shares or tendered them by way of surrender on the 8th of October 2012?
It is, my Lord.
For cancellation?
Indeed, my Lord.
Have they ever been cancelled?
My Lord, I don't believe they have. I don't believe they have. I think the submission by Sir Hamid, and I think everyone was alive to that. The problem is that it's not on the evidence.
No, but I'm just quite interested to know.
Yes, I understand. And
it may be relevant to the cross-appeal.
Yes and no, my Lord, because I will show you now the submission by Sir Hamid was that it didn't matter whether they were cancelled or not, because they were, once you've surrendered them, they're held on trust by the company. I will give you the reference in a moment.
That may be so, but the machinery was for something very different than the shares being held on trust.
And not followed.
But you say the machinery had broken down in by the hearing of an arbitration several years later. I mean, what caused the breakdown if shares offered by way of surrender had been held by Vsoft since October 2012?
Well, that was the question, and it would have been perfect.
Well, yes, but what's the answer? What's your case about why the machinery broke down?
Well, the case is because of late surrender of the shares.
But why should that cause? I can quite see why that might cause the machinery to run slow, but why did it cause the machinery to break down?
The submission of Mr. Chetty, again, my Lord, the difficulty is that my case is simply that the arbitrator had to decide that question. Now, there are two consequences that can flow from the late surrender. And Mr. Chetty was putting the basis.
First of all, why do you say it's late? First of all, I'm not
because,
clear about
sorry,
that.
So then we're coming back to the analysis.
There's no date specified in Clause 5.
My Lord, then we go back to the analysis of Clauses 3 and 5. And my submission is that the way in which Clause 5 is drafted clearly requires that in order for the debt to arise, there must first have been a surrender of the shares. And I think the witness for Peepul was alive to that. And when he gives evidence as to why he has held on to the shares, he does say, well, from the 3rd of May to the 8th of October, I decided
So
not to surrender.
the first tranche was due to be paid prior to the end of August.
31st of August. Mr.
So are you saying that the surrender of the shares had to be done before the end of August?
My Lord,
Is that the argument?
Yes, and what would be expected is that this being an agreement which the funders themselves was designed to effect a conversion of their equity shareholding into debt, the surrender would have been made immediately. But in terms of simply contractual construction, you will remember I showed you clause 5b, which shows that 5a, you must have a surrender of the shares. You must have a cancellation of the shares. 5b, upon cancellation of the shares, here are the security interests which Peepul is going to be given. And those security interests refer to the tranches or the payment of the tranches as future events. This is not consistent with payment having to be done after 31st of August.
And so if the shares are surrendered at any point after the 31st of August, the agreement nonetheless comes to an end. There are no amounts due under clause 3, and nothing has to be done.
My Lord, the submission of Mr. Chetty was that the machinery had broken down. Now, that submission could be dismissed, but it was live. And there are, in terms of substantial injustice, I can understand. Let's assume that that broader argument, nothing is due, doesn't arise. But
that seems to be implicit in the denial that the 17 million was payable.
Yes, my Lord. That's the position that is being taken. But once Mr. Chetty, after the intervention, says you need to determine where we are in the implementation process, let's focus for a moment on substantial injustice or the discretion. Then what ought to have happened is that the arbitrator should have looked at those clauses to see where they were in the implementation process, and two things would have happened, we say. First, there would have been a question as to whether interest was payable prior to 8th of October 2012. Why would they be entitled to interest prior to that date in circumstances where they surrender deliberately the shares late? And secondly, my lords, very importantly, he would have had to say what the fate of the shares was. He would have had to make a finding, one sentence. Shares are no longer the funders. They have been surrendered. They have been converted into a debt, absent from the award, and this would have been required on any analysis of the implementation process because it's the very first step. So he would have had to go to the machinery and say, this is my analysis of how this works, and of course, recorded in the award, those shares have been surrendered and converted into debt. Now, this is absent from the award because he never determined that live issue. And this is precisely, my lords, what is now allowing the other party to come and tell Indian courts, to come and tell absolutely everyone, yes, we did tell the arbitrator that we had a debt which had arisen from the conversion of our equity shareholding. We did enforce that. We have an award worth now about $30 million to show for it. But also, of course, we still have that equity shareholding, which was there in the first place. But also, that arises because the arbitrator has not determined the live issue of where we were on the implementation process.
I think you told me a moment ago there was really, when I asked you whether in fact the proffered surrendered shares had actually been cancelled, you said you thought they probably hadn't, but there was no evidence about it.
There's no evidence on the record, my lord.
Well, if there was no evidence before the arbitrator as to whether the shares, which had by then been proffered for surrender years previously, had actually been cancelled, how could he make a finding about it?
I apologize, my lord. No, there was evidence, sorry, there was evidence that by August 2013 they hadn't been cancelled because at that point in time, do we have the reference?
There's that exchange of correspondence.
Exactly. Let me give you the reference for that.
But I'm talking about at the time of the arbitration.
Well, there was no suggestion that that had changed by the time of the arbitration. In the arbitration, questions are asked of the witnesses about that. And the situation is still, well, they want that, but we don't say that's a proper mechanism. That was the status at the time of the arbitration. And what I will do, my lord, if perhaps rather than lose time now, I'll just draw up the 3 or 4 references that are relevant to that over lunch, which is the share transfer demand and where the witnesses have dealt with this, and I will give that to you. We're a long way away from the exercise of discretion, Lord, which is where we were.
I don't think you need, I mean, I'm not sure if there's any real issue there, but if it could have led to a different result, then the court, if it had been a failure of natural justice, which may have affected the outcome, then the court would have to intervene. I don't think that's, no, that's, you don't have to address us on that.
Good.
We're
so the test is might, rather than could. And just one other point to cover, which is linked, which is section 34B2, substantial prejudice, I believe. Sorry, 39.2B4, substantial prejudice. So as you have seen, this is one of the 2 grounds we rely on with respect to the failure of due process. And as I have shown you, that's not a typical model law ground, but was introduced by the Mauritian legislation for clarificatory purposes. And a question arises, of course, as to what the relevant test for substantial prejudice is under that specific subsection. We're not going to find equivalent model law jurisprudence. So we respectfully submit that the test under this clarificatory provision is not substantially different from that applicable to the exercise of discretion under the chapeau of 39.2. The wording of 39.2b4, we submit, is similar to that of section 68 of the English Act, which requires that a procedural irregularity, which is defined in the Act as serious irregularity, has caused or will cause substantial injustice to the applicant. And you see that, my lords, at tab 18, page 2328 of the bundle. So if you could just take a brief look at that, I'm sure you will be...
Did you say 238?
2328.
2328, thank you.
You'll be very familiar with it, our legislation here. Serious irregularity means an irregularity of one or more of the following kinds, which the court considers has caused or will cause substantial injustice. So the words in 68.2, substantial injustice, the words in 39.2b4, substantial prejudice. And if we could turn briefly, my lords, to the decision of Mr. Justice Coleman in V Networks, which you will find at page 2327 of the record, Authorities, tab 17. I apologize. The decision starts at 2310, 2310, and the passage I want to take you to is the very last, the penultimate paragraph, the anti-penultimate paragraph, which is 19 at 2327. And this is what Mr. Justice Coleman said: it is unnecessary and in the circumstances undesirable for me to express a view as to whether the arbitrator came to the right conclusion, even if by the wrong route, or whether, had he ignored the 2003 amendments, he should have reached the same or a different conclusion. The element of serious injustice in the context of section 68 does not in such a case depend on the arbitrator having come to the wrong conclusion as a matter of law or fact, but whether he was caused by adopting inappropriate means to reach one conclusion, whereas had he adopted appropriate means, he might well have reached another conclusion favorable to the applicant. Thus, where there has been an irregularity of procedure, it is enough if it is shown that it caused the arbitrator to reach a conclusion unfavorable to the applicant, which, but for the irregularity, he might well never have reached, provided always that the opposite conclusion is at least reasonably arguable, which we certainly say is the case on the clause 3, clause 5 point. Above all, it is not normally appropriate for the court to try the material issue in order to ascertain whether substantial injustice has been caused. To do so would be an entirely inappropriate inroad into the autonomy of the arbitral process. So for that reason, my lords, again, we submit that the test is not materially different under 39.2b4 than the test under the chapeau of 39.2 and the word may. My lords, that only leaves me to deal with the question of public policy, which is a separate ground from infra petita and the position if, in fact, the issue was considered, which I have just covered, and then very briefly the question of remedies. My lords, I'm in your hands as to whether you want me to continue now or resume after lunch.
We could carry on for a couple of minutes,
Sure,
perhaps.
of course, my lord. On public policy, my lords, we respectfully submit that this award should be set aside on the additional ground that it contravenes the Mauritian in the universal public policy against double recovery, in that it has left the funders free to claim both the fruits of the award, i.e. the enforcement of a debt of $17 million together with very substantial interest, which the funders obtained on the basis that it represented the conversion of their initial equity shareholding into debt, and two, that they still hold that initial equity shareholding. Factually, my lords, perhaps we can use the few minutes left to take you briefly to the record to show you the funders' repeated assertions following their obtaining the award that they are currently still equity shareholders in Vsoft and in fact also entitled to voting rights arising in the preference shares which they accept whenever issued to them. And if I can show that to you, it's all in volume 4. The first such occurrence on the record is a letter from an advocate acting for the funders to the registrar of companies, which you find at page 1255 of volume 4.
The registrar of companies in India.
It is, my lord. Well, in Hyderabad, I think there are various registries in the various states. So this is in the state of Telangana. And the passage I rely on is at paragraph 7 on page 1258. And it's 4 lines from the bottom. My clients are having more than 35% shareholding and 77% voting rights in the Vsoft holdings, i.e. The appellant here. That is an assertion made in July 2016, well after the award has been obtained, on the express basis that they have a debt which has been enforced through the award by reason of a conversion of that shareholding. Why can they say that? Precisely, my lords, we submit because the arbiter did not decide, I quote, where we are in the implementation process. The next occurrence, my lords,
How many assertions do you need?
There are only 3. May I? And they are all...
Do the others add anything to this one?
They do. Hyderabad Court, page 1263 at 1276. I'll take it very quickly, my lord. Paragraph 11. Under the agreement, the plaintiffs, that is, the funders, until they are provided an exit in terms of clause 3, are holding about 35% of the issued and paid up share capital of the defendant number 5. And the reason I say we can add something is if you look at the affidavit which is filed in support at page 1328. Sorry, that's in support of another set of proceedings. And if you turn back to 1314, I just want to show you the identity of the person swearing that affidavit.
I'm not quite, I don't understand this. They haven't got their money.
Yeah.
My lord?
They haven't got their money. That's what we're arguing about here. So there's no double recovery at this stage.
No.
They're saying they hang on to the shares. what their position would be when eventually you pay them, who knows? I mean,
But my
how are
lord-
we concerned with this?
But it's a bit more complex than that in our respectful submission, because the award has left them free to do that. And what that means
Yes, but
is
the
that...
award, the position we're in is you haven't paid the money.
But,
So how can you complain of double recovery?
But does that mean that they have a choice now as to whether they can claim to be shareholders?
But it's your choice. They've tendered the shares for cancellation. As I understand it, you haven't cancelled them. I can quite understand why you haven't if you haven't paid the money. But the fact is that the reason why the shares are still held for them is not because they're holding on to them. They've sent them to you for cancellation and you haven't cancelled them.
With respect, that's not consistent with the submission that was made in the arbitration by Sir Hamid, that the shares were now being held on trust by the company.
Why?
So that was their position in the
Yes,
arbitration.
but why is that inconsistent?
It's not consistent because they said that in order to explain why the debt arose. The debt, my lord, they asserted themselves. It's paragraph 9C of their reply. Our debt arises from conversion of the equity. That was their position. And when pressed on this, Sir Hamid explained, well, it's now being held on trust by the company. What they are now doing, so they could say, well, the shares are there, you do what you want with them. We're not asserting rights. Here they are asserting rights. So are they at the same time allowed to assert that they are equity investors with all that entails with respect to participating in the fate of the company, but we are also debt holders with all that entails with having the security of a debt? But how can that be? If they had not acted as they have acted, I could understand the force of what you have just said, my lord, which is, this is all hypothetical. It's not hypothetical, because the award always left that possibility open. And that did not happen by inadvertent. Well, it happened, we submit, because precisely the arbitrator did not decide a live issue. He did not decide where we are in the implementation process. And it's not hypothetical, because this is not a position where the funders are saying, well, we've surrendered maybe as Sir Hamid, and I will show that to you after the break. They're now held on trust by the company. They're now saying, we are entitled to the award. Here they are, asking for enforcement of it, refusing annulment of it. But at the same time, we can go about and assert that we are active shareholders, that these shares we are allowed to exercise rights under. That is our point, my lord.
Well, I think we understand what you're saying. We'll adjourn now and sit again at 2 o'clock.